Welcome to our second lecture covering Module 7, which is our module about national origin discrimination. In our first lecture, we discussed demographic changes in our country. We discussed an overview of how national origin employment law claims work, and we discussed English-only policies, which oftentimes are related to national origin policies. In this presentation, we're going to discuss national origin harassment claims, the OFCCP process, especially as it relates to national origin situations. We'll discuss IRCA and Section 1981. So let's begin. So just like any other type of protected category under Title VII, you can have, in addition to the discrimination claim, you can have a harassment claim. And the structure of the claim works in the same way as we've talked about in the race harassment situation. That Farragher-Ellerth paradigm applies to national origin as well. And we see the same prima facie case that we saw with race harassment claims. First of all, the harassment must be unwelcome. In a playful, combative work environment, it may be that people say all kinds of things that are kind of offensive, but everybody gets it's just in good fun. And the person who is the quote-unquote victim of it may give as good as he or she gets. In that situation, the banter would not be unwelcome. It would be part of an environment. Maybe it wouldn't be what you and I would want for our working conditions, but there are people out there that enjoy that, which is fine. So it has to be unwelcome. But when we say unwelcome, it's also important to keep in mind that the threshold isn't frightening. The person doesn't have to be afraid that he or she is going to be beaten up or harmed in some way physically. So, you know, it's unwelcome, but it doesn't have to be physically intimidating. Obviously, if it is physically intimidating, that even makes it a stronger harassment claim. It does need to be severe or pervasive. Usually a single incident or even a few incidents aren't going to count unless, again, they're very extreme. It has to make the job significantly more difficult than it would have otherwise. This can be in terms of actual performance of the job, meaning people are not helping that person as they should complete the job, or it can be that the emotional strain of coming to this work environment is really taking a toll on the person. And then, of course, there has to be that employer link. And keep in mind that the employer has that affirmative defense that we talked about, that Farragher-Ellerth affirmative defense. So let's consider some situations that can arise in the national origin harassment scenario. In our case, Tang works for Bob, and Bob told Tang one day that foreigners should stop seeking jobs in the U.S. if they cannot perform. And the implication was Tang was one of those people who cannot perform. Given the fact that this is a one-time thing that Bob said, while it's not appropriate, it would not in and of itself create a hostile work environment. If that were something that Bob said regularly to Tang, you know, once a day or once a week, and he said it in an intimidating way, and it seemed to be directed at Tang, then yes, it could possibly be a national origin harassment situation. This next one is a little bit more complex. Let's talk about it. So Bob is a resident in a nursing home. So he is not an employee. He is a client or a patient of the employer. He often makes ethnic slurs about Mary, who is a Filipino employee of the nursing home. Sometimes he complains that Mary is not qualified for a job and needs to be replaced. Mary reports these statements to her supervisor, but the supervisor's response is, ignore Bob. Under those circumstances, Mary may have a claim of national origin harassment because the nursing home took no action to stop Bob's behavior. Now, this is a complex situation because it could be that Bob is experiencing some type of dementia or some kind of psychiatric issue. And so it may not be meaningful to talk to Bob. He may not remember it, or he may not have impulse control at this point. But the nursing home ought to attempt to do those things. At the end of the day, it may not be possible for the nursing home to rein in Bob's behavior. And I guess part of that may turn on whether Bob can rein in his own behavior. Some solutions might be to schedule Mary to work at a different part of the nursing home. That may or may not be possible given the staffing circumstances in that nursing home. But the nursing home should have at least tried these things. Now, can the nursing home be responsible for what every customer says, especially in the case of a resident in a nursing home? No. It can counsel Bob, and certainly if Bob is physically threatening Mary, then Bob may need to be asked to move to another facility. In this case, it doesn't seem like he's physically threatening her, although he's threatening her livelihood, but it seems pretty clear in the circumstances that people aren't taking that too seriously, that Bob has the authority or the power to end Mary's employment. So I have here that the nursing home is liable. I would say more likely the nursing home may be liable. So I'm going to put a little question mark here. And again, I would be interested in knowing a little bit more about Bob's situation and about what the nursing home has done. So you have to consider the effect on the victim. Now, there are probably people in Mary's situation who think to themselves, whatever, Bob. you know, whatever. If you want to say that stuff, I'm not paying attention. You do you and I'll do me, that type of thing. In that situation, if Mary is unaffected by it, then there's no harassment. The victim must respond on an emotional level to this. And so some people it would affect, some people it would be no big deal. And that may also turn on Bob's situation. If Mary understands that Bob is in dementia and that he really doesn't understand what he's saying, that might influence her worldview of how to interpret Bob. Let's discuss the OFCCP. This is the Office of Contract Procedures. I'm not sure exactly what it stands for, to be honest with you. It is the agency in the federal government that sets up the guidelines for federal contractors, what they have to do to comply in terms of the reporting they have to do on their affirmative action and their EEO compliance projects or requirements. The guidelines on discrimination based upon religion or national origin is something the OFCCP has developed. These only apply to federal contractors or governmental agencies, and they do impose an affirmative duty to prevent discrimination. We aren't covering the affirmative action chapter except as an extra credit opportunity because it's not a very common thing that we're doing, at least at this point. That may change in the future. But of course, if you are choosing to work for a federal contractor, then that's a very important chapter for your employment prospects. As I say, it applies only to federal government agencies and employers who supply goods and services to government entities. Let me pause here and talk a little bit about this. This is a little bit out of the HR wheelhouse, and yet it can be important. I remember once I had a client call me and say, our lucky day, we just got an order for, I can't remember how many it was, maybe it was 50 or 100 or 200 shirts. Some local federal agency wanted to get these shirts for a charitable activity or something like that. And they came to us and wanted us to fill it, and we're just so thrilled. And I said to them, well, that's probably the most expensive job that you're ever going to take on, because you may, depending upon the amount of money, you may become a federal contractor. And once you become a federal contractor, you're going to have to comply with all the OFCCP rules. As a result, it's a major business decision to decide whether you're going to want to take that on. And usually companies only take that on when they anticipate that they're going to make a significant amount of money, because the compliance costs are going to be high. So you don't want to, earn $20,000 in profit and spend $70,000 to comply with the law. If it is a multi-unit company and only one unit is actually having the contract, the scope of the law is going to affect all of the units. And so there is no getting out of that. And so one of the things that's a very smart plan for businesses that don't want to be government contractors is to educate their units about the fact that they should never enter into a contract with a government agency. Now, obviously, a government agency can walk into a Walmart and buy stuff. That doesn't make the Walmart a government contractor. It's only when they enter into a negotiated contract. But sometimes it's possible to fall into those arrangements with people who don't have necessarily an understanding of the complexity of the issue. Obviously, under the guidelines on discrimination based upon religion, national origin, it's unlawful to refuse to hire somebody or refuse to retain somebody based upon their religion or national origin. Obviously, that's true not just under these guidelines, but under Title VII generally. And the guidelines obviously prohibit discrimination. You might say, well, big deal. Employers already can't discriminate under Title VII. The issue isn't so much that the OFCCP puts new legal burdens on employers. It just requires a lot of record keeping and reporting. And then, of course, there is that affirmative action duty. But the paperwork compliance side of it is really, really large activity. And so it can make sense to do it in the right case, but it's certainly something that the whole organization ought to understand whether this is the right decision to make or not. I have a link here. I'm just going to show you that link right now. We're not going to spend time. I just want to show it to you. Here we go. Here's a page from the CFR, which is the Code of Federal Regulations. And here is the language that we're talking about here. This outlines the particular categories that are covered in this part of the OFCCP regulations. Here it is. The Office of Federal Contract Compliance Programs. That's what OFCCP stands for. Okay, let's go to our next slide. So these guidelines put particular attention on Eastern European, Middle European, and Southern European ancestry individuals. So, for example, Bulgaria, Spain, Italy, Portugal, Greece, Armenia, Poland, those would be places that would be covered. And it would include people of the Jewish faith, people who are Catholic, people who are Greek, especially Greek Orthodox, and people who are Slavic. Again, people who might be Russian, for example, would fall into those categories. Now you might say, well, why do they focus on those categories? There's lots of other national origins. Why are those the focus? Well, in part because even though they're protected under the national origin protection, the focus of Title VII has always been with these categories. So yes, these folks are covered by Title VII national origin protections, as are these folks, although the African Americans are covered primarily through the race category. But because these have historically been the focus of Title VII, the OFCCP wanted to give these categories of individuals who have at times experienced discrimination as well, protection under the guidelines. So the failure of these guidelines to mention Spanish surnamed Americans, Asians, Native Americans, and African Americans doesn't mean that they aren't entitled to every bit as much protection. It's just this is designed to highlight a category that sometimes gets overlooked. Let's look at IRCA, the Immigration Reform and Control Act. We will talk more about immigration law in later units, so this is not the only time you'll be seeing this material. So here is how we define an alien who's authorized to work in the United States. First of all, let's refresh. An alien is not somebody in a sci-fi movie. We're talking about somebody who is a citizen of another country. And so he or she can be authorized to work in the United States through kind of two paths. One path is he possesses, we'll say he for simplicity, he possesses a valid Social Security number card. Let me pause here and say that there are Social Security cards that specifically say that they do not convey eligibility to work. Obviously, that kind of card isn't going to work for this purpose. But an unrestricted Social Security card is evidence that this person is authorized to work. And then the other, and so that's one way. So we have an or here, which means you don't need both of these. You just need one or the other. Or other documentation evidencing authorization of employment in the United States, which the Attorney General, here we're talking U.S. Attorney General, finds by regulation to be acceptable for purposes of this section. And we'll see that this category is a catch-all of all kinds of different things. So there are lots of different ways that an alien can prove that he or she is authorized to work in the United States. It's not just a one or two item list. So here we have a partial list of what those documentation might look like. One is a green card. The green card once upon a time was green, but it's no longer green. However, the name of it is the same. The actual official, or the nickname of it, I guess you could say, the official name of it is Resident Alien Card. So this is called a Permanent Resident Card, and it can be called a Form I-551. All of these grant permanent residence. This can be revoked, despite the name permanent residence. But the implication here is that the person, the plan is this person will reside in the United States for as long as he or she wants. It can be revoked, but the assumption is that it won't be revoked. So it doesn't need to be renewed periodically. You can also have temporary residence status for refugees and asylees in certain circumstances. This will expire. Sometimes it's issued individually per asylee or refugee. Sometimes it's issued in categories. So there will be a time where people from a particular country, for example, Rwanda, are allowed to be asylees or refugees. And then there will be a date when all of those individuals will no longer be eligible to work under this category. Sometimes it has to do with when unrest in that country is ended or whatever the circumstances are. Aliens who are admitted as a non-immigrant spouse or child of such an alien can also be covered and eligible to work. So those are some examples. Now this sounds like there's only 3 examples, but there are dozens of different documents that can satisfy these. So it can be a very complex system. So while aliens generally have the same rights of employment, assuming they're authorized to work, as a citizen would have, there are just a few carved out positions that are reserved for citizens. And these are called political function type jobs. And typically they are limited by statute. And the statute says only U.S. citizens are eligible for those. There is, for Title VII and for IRCA, there is this political function exception. And the idea here is, well, if you are in a role in the government that you're making policy, then it's reasonable to say, well, only U.S. citizens should be making policy decisions within the government. Now, of course, there's lots of different roles in the federal government, and if I'm a secretary or a file clerk or an administrative person, then the political function would not apply, and I would be eligible for employment. But again, if I'm making policy, then oftentimes the political function would exempt those who are not citizens of the country. Again, the IRCA is the Immigration Reform and Control Act. We talked previously how the employment limitation is 4 for employment discrimination. So between 4 and 14, IRCA applies. When it's 15 or more, Title VII applies. Now, with respect to Title VII, we've talked about how many times the employer may not be aware that his or her actions is discriminatory. It's not a protection for the employer. It's a good fact. It possibly will diminish or maybe even remove the risk of punitive damages or compensatory damages, but it's not going to remove liability. URCA is different though. Under URCA, the unlawful act has to be knowing. And knowing does include kind of turning a blind eye there. You know, for example, let's say I am not authorized to work in the United States. And so I, with a cheapo photocopier, make a driver's license that claims to be a Texas driver's license, but anybody who's seen a Texas driver's license could look at it and go, it doesn't look too legit to me. Anyway, I take it to work and say, here's my Texas driver's license. This is my proof that I am who I say I am. And the clerk looks at it, and the clerk's a Texan. She knows what a driver's license looks like. She goes, okay, you provided the form. I'm going to accept it. Well, that would be, she knows better. She knows it's not a legitimate form. She's pretending that she doesn't know. And she can't say, well, gosh, I didn't really look at it. That's her job. For I-9 purposes, she has the duty to genuinely check it out. She's not expected to be a forensic expert. There are fake driver's licenses out there that she could easily argue were sufficiently credible that it was reasonable for her to trust it. But one made off of a photocopy machine at home, probably not going to cut the mustard. So you can't say I didn't know when common sense would have told you that I did know. But it does have that knowing requirement that we don't have with Title VII. So let's compare some of the provisions here. So under Title VII, we have the disparate treatment claim, which is, again, the traditional discrimination claim. It's what you and I think of when we think of discrimination. Then we have the disparate impact, which is when a firm has a facially neutral policy that they apply consistently, but it tends to affect one group more than the other. For example, having a height requirement, being so tall may exclude, will exclude more women than men, and may exclude minorities that are, minority groups that are typically are shorter in height. IRCA does not have a disparate impact component. So for those 4 to 14 employees, it has to be knowing and intentional discrimination. So I would argue that it's not even just enough that it be disparate treatment, but it has to be something that is almost more knowing than that. For example, you can make a disparate treatment claim between two supervisors. Let's imagine you had a and this is under Title VII. Let's imagine you have a workforce where you have 100 supervisors, and one person is really strict about attendance. He's consistent. He disciplines people consistently, whether they're white or Hispanic or African American. Across the warehouse, there's another supervisor. I mean, these two people barely know each other because there's 100 of them. And this person is super slack. He doesn't really enforce the attendance rules very much at all, but he's consistent. He doesn't enforce it against the white people. He doesn't enforce it against the Hispanic people. He doesn't enforce it against the African American people. So the strict supervisor fires an African American due to attendance. The African American knows a white person in the lenient supervisors unit, and that particular worker has much worse attendance than the African American who was just dismissed. So now the African American has a comparator that he can point to and say, look, Bob, the white guy in my same unit, has worse attendance than me, but he's still employed and I'm not. And under those circumstances, it could be that that would go to the jury. The jury might award damages under Title VII for disparate treatment. That type of case is probably not going to survive under IRCA because there was no intention to be discriminatory. You can see within a supervisor, each supervisor acted consistently and there was no intent to discriminate. So it's a little bit harder even to make a disparate treatment claim under IRCA than under Title VII. Innocent or negligent discrimination is a complete defense. If you were just being careless, If you testify, oh, just two supervisors of different styles, that's probably enough to get you out of that case in an IRCA environment. Let's consider these two scenarios. So Carlos is on the petite side. He's only 5'5", which isn't an unusual height for a Mexican-American man. He applies for a job, but he doesn't get it because the height requirement for this position is 5'8". Let's assume that this doesn't have a business necessity. There was no need for a mechanic to be of a certain height to be successful in the job. If that's true, if the employer cannot make a successful business necessity argument, then Carlos has a good chance of winning a national origin claim, again, because his national origin, Mexican-American, is less likely to meet that 5'8" threshold. Now let's say Carlos were a African-American. I don't know statistically, but I guess my sense is that African-Americans don't tend to be shorter than the average U.S. population. Obviously, an individual African-American could be shorter, so we could change Carlos to an African-American. He still wouldn't get the job, but he would have a hard time making a discrimination claim because he's no longer Hispanic in this story, he's African-American. And unless he can show statistics that show African-Americans are statistically shorter than the general population, that's not going to be a winning argument. Luis is a Mexican citizen. He's eligible to work though, so he's got the documentation that he needs. And he works for a company with 12 employees. So Title VII doesn't apply because they haven't reached this 15 threshold, but IRCA does apply. He has better qualifications than Bob, one of his coworkers. We're going to say Bob is white and a native-born American. Luis and Bob apply for the same job and Bob gets it. Luis overhears his employer say that the employer would never promote a Mexican citizen over a quote-unquote real American. Apparently the employer has forgotten that Mexico is part of North America, but that's a geography lesson perhaps. Anyway, Luis files a claim of national origin discrimination, and he quite possibly will be successful because he can show that he was denied a promotion for which he was more eligible for. There's obviously no political function going on here. This is a private employer, so that wouldn't apply. So it looks like a pretty strong case of intentional discrimination. IRCA makes it unlawful for employers to hire, recruit, or refer for a fee unauthorized workers. So again, you may recall we talked about how IRCA kind of has a tension there. On the one side, it prohibits hiring unauthorized workers. On the other hand, it precludes discrimination based upon national origin. There are both civil and criminal penalties associated with hiring undocumented aliens, so it's important that companies get that right. Companies can be civilly prosecuted and individuals can as well. As a result, it's important that employers follow those rules and make sure that only people who are eligible to work continue to work for the employer. And the form that we use for this to verify employment is a government form called I-9. You do need to know this name, and it needs to be completed within 3 days of the date that the employment begins. If an employee submits a document that doesn't appear to be genuine, then the way to get the matter resolved is, sometimes the employer will go to a law firm, and sometimes the law firm can research the issue and see if it's a legitimate form or not. But the employer can also go directly to the government and say, hey, confirm that this is a legitimate document. Oftentimes under these circumstances, the employer doesn't go directly to the government, but uses the law firm so that they can go to the government in an anonymous capacity. So that can be a way around that. Let's consider these scenarios. So Bob hires an alien worker named Larry. Because of Larry's qualifications and the cost Bob's company will incur if he is hired, Bob doesn't ask for all the documents he needs to, so no I-9 is completed. Bob can be held liable both criminally and civilly for letting Larry work beyond the 3rd day without getting the documentation. And this is a violation even if Larry ends up being a U.S. citizen. So you may have someone walk into your place of employment who has a typical American accent, and he has a typical American name, and he's got a driver's license or whatever, and he seems to know the typical stuff an American would know, and you may think, well, he's got to be an American citizen. Why do I need to do all this silly I-9 stuff? Well, maybe he immigrated to the United States when he was a child. He may not be eligible to work here, even if he has learned English and is a fluent English speaker. Or maybe he's from Canada. Or maybe he's just very, very skilled at accents. Whatever the issue is, you need to follow the process even if you think this person is definitely a citizen. It would be discriminatory to only require those that you think might not be a citizen of doing the I-9 process. And you will be held responsible for Larry's lack of form, because obviously you don't know whether Larry's eligible or not until you get the documentation. So the question isn't, oh, well, was Larry ultimately ineligible to work? No, the question is, did you follow the paperwork? It doesn't really matter whether he would have been able to prove it or not. Okay, let's consider Francois. Francois is an alien working in the United States, and he has the legal authority to do so. Many types of legal authority can expire. For example, Francois may be on a visa in which employment eligibility ends at some point. Sometimes also employment eligibility is tied to a particular employer. In that situation, the employer, if it's a date where Francois will lose his eligibility to work, the employer needs to calendar that date and get with Francois at least, I would say, 2 weeks before that date and say, hey, Francois, do you have additional documentation to show that you are going to continue to be eligible after this date? And if he does, awesome, great, you're going to complete another I-9. So that will go into effect at the time that the first one is no longer effective, because the first one will show the expiry date. Unfortunately, for people in Francois' situation, it's not unusual, especially in the post 9/11 universe, it's not unusual for the government to be slow about renewing these documents. Many people are eligible to get these documents, and they will be renewed, but they may request renewal months or even a year in advance, and it may take longer to get that taken care of than the documents they're relying upon are still going to be in effect. There can be a gap. Now, I've been in a situation where I've actually gotten a letter from a congressman, a U.S. congressman, saying, please let this person work longer. It's not their fault they don't have the documentation. And I believe the congressman and I believe the worker, but the law is really clear. An employer cannot have someone work even a day longer than their employment eligibility. There's no gray area. There's no discretion that the employer has. It can be a very unfortunate situation, but it's not for the employer to bend that rule. I tell you, I've heard some tragic stories. I'm not exaggerating when I say that, of people who whose employment had to end for reasons that they were completely not responsible for. But that's the way the law is written. The EEOC, let's talk about this. Now, the EEOC does not administer IRCA, but obviously it administers Title VII. So it administers the national origin discrimination for employees who have over 15 or more employees. Its position is that the worker's undocumented status does not change its approach to employment discrimination. You keep in mind, it's not enforcing IRCA, which of course IRCA prohibits unauthorized employees from working. But Title VII says we're not focused on whether this person has their I-9 paperwork correct. We are going to focus on eliminating the employment discrimination. And so under those circumstances, employers who are found to have discriminated or harassed an undocumented worker can be liable for monetary remedies to that undocumented worker, even though that undocumented worker never should have been hired in the first place. Okay, let's talk about the Fair Labor Standards Act. for the FLSA. This also protects unauthorized workers from the possibility of abuse, for example, sub-minimum wage situations or not receiving overtime pay or things like that. So both of these laws don't focus on the undocumented status of the worker to figure out whether they are entitled to relief. Let's consider this situation. So Omar is an undocumented worker. He works for mink manufacturing. He's routinely harassed because he's from the Middle East. People call him nasty names, say he's a terrorist. He complains about the conduct, and after a few days, the supervisor kind of wants to retaliate against him, so he investigates not what's happening to Omar, but he investigates Omar and finds out that Omar is an undocumented worker. The supervisor wants to get rid of Omar because in his mind, Omar is a troublemaker because he's reporting, he's doing what he's supposed to, he's engaging in oppositional conduct. And so the supervisor reports Omar to the INS. Under those situations, that would be considered retaliation because the only reason the supervisor knew about Omar's illegal status, people aren't illegal, but they may be undocumented. Undocumented status, if he hadn't done that review, and he only did that review because of the complaint, then that would be considered retaliation under Title VII. But let's look at this case here. Okay. Is the NLRB authorized to award back pay for violations of the NLRA, National Labor Relations Act? NLRB is the National Labor Relations Board, so it's the agency. This agency is the equivalent of the EEOC for labor matters. And this is the equivalent of Title VII for labor matters. So is the NLRB authorized to award back pay for violations of the NLRA to an undocumented worker who was unlawfully terminated from his employment? So at the beginning of the employment, Mr. Castro submitted a false birth certificate. He did this so that he could provide the I-9 documentation that was required. The employer thought it was legitimate, or at least looked the other way. If Mr. Castro hadn't submitted this fake birth certificate, he wouldn't have been able to get the position because he wouldn't have been able to get beyond that third day of employment. So after he's working for the company, he begins to get involved in union organizing. He's terminated, and the National Labor Relations Board concludes that the reason he was terminated was because of his union organizing. It wasn't the quality of his work. It wasn't the fact that he was ineligible to work. It was that he was a union organizer. Well, that's an unlawful reason to dismiss somebody under the NLRA. In a 5-4 decision, the Supreme Court determined that the NLRB was not authorized to award back pay because to do so would be to violate URAC's prohibition on the employment of aliens. So unlike the EEOC and the National Labor Relations Act, at least with respect to the NLRA, the U.S. Supreme Court says no, there can't be back pay under these circumstances. So we haven't seen a case by the U.S. Supreme Court that addresses Title VII or the FLSA. It'll be interesting to see if and when that happens. It's a bit of a gray issue. You can see arguments both pro and con. You can see the U.S. Supreme Court's argument, which is, well, Mr. Castro never should have been hired. And now that we know that he's unlawful, it'd be pretty ridiculous of us to give him money that he should never have earned. So that's the argument for the position of the U.S. Supreme Court. But there's also a strong argument against the position because after all, Mr. Castro, assuming that what the NLRB said is correct, which we will for the sake of this argument, the law was violated. He was the victim of unlawful behavior. So if employers are allowed to mistreat and abuse undocumented workers, that's not a good thing. That is not something we want to have in our society. And so by allowing basically the employer to get away with the mistreatment of Mr. Castro simply because he was undocumented, that kind of makes all workers a little bit less secure in their jobs. So let's look at what IRCA requires that employers do. So they have to identify, and this is a two-step process. So there's an and here, not an or. They have to verify the identity of the person and the employment authorization of the person. Now this can be done through one document. For example, I can show my US passport. If I have a US passport, then that means I'm authorized to work in the United States. Plus on the passport, there's going to be my name and my picture. So the employer can look at the picture and look at my name and see if it matches. If it does, then they have verified that I am the person in the passport and the person in the passport is authorized to work. So there can be situations where a single document accomplishes both goals. But oftentimes employees or potential employees or beginning employees will do the two-document approach. And the most common combination here is an unrestricted Social Security card and a driver's license. The driver's license, so let's say the Social Security card says Bob Smith. And then the driver's license says Bob Smith. And then the driver's license has a picture. And the picture looks like the guy who's presenting it. So you know that the person is Bob Smith because he looks like his picture on his driver's license. And then you see the Social Security card, which has the same name. And that person has an unrestricted Social Security card, which means he or she is eligible to work. You can instead use a birth certificate indicating a birth in the United States. Again, there's no picture on that, so you're going to need to have a driver's license or some other type of state identification with some type of picture on it. And there's several different things you can use in that area. Under IRCA, if an employee gains employment with false documentation but later gets proper work authorization, then you need to do another I-9. The employer has to do another I-9. We already talked about the threshold of employees. We talked about there can't be discrimination based upon national origin or citizenship status. So a person who is a Canadian citizen, we don't really think of Canadian national origin unless someone is a native Canadian in the sense of they're what we used to call Indian or Aleuts. So citizenship would be the issue in that situation. And again, unless it's one of those political function roles, citizenship can't be the basis. You can't prefer U.S. citizens over, say, French citizens or South African citizens or Vietnamese citizens. IRCA prohibits employers from refusing to hire non-citizens with work permits or those non-citizens whose appearance characterize them as non-native born persons. So as you can imagine, if somebody who looks like me and sounds like me applies in it for a job, the assumption people are going to have is that I am a U.S. citizen. My accent sounds American, and so they would be astonished if it ends up that I'm really Canadian or something else. Most employers will check because they want to comply with I-9, but they aren't really thinking I might not be eligible. But somebody who had a foreign accent, the employer might be much more skeptical of or suspicious of. And that's one of the things that IRCA's non-discrimination component is designed to reduce or eliminate. Because the concern with IRCA was, well, if we tell employers that if they hire an undocumented worker accidentally, they could be subject to fines, what they may choose to do is just hire people who sound like Cynthia Gruber, who don't have a hint of an accent, who look like a typical American person. And that obviously was not the goal of the law. So the two parts are really designed to, even though there's some tension between them, the two parts were designed to work together. And an employer can't say, well, we're just going to play it safe and just hire people we're like 99.9% sure eligible to work in the United States. So the people who are protected under IRCA from discrimination would include a citizen of the United States, and of course a national basically is a citizen, a naturalized citizen, or an alien who is lawfully admitted for permanent residency in other words, has that green card, lawfully admitted for temporary residency, admitted as a refugee, or admitted as an asylee. And so the fact that they might have an accent, the fact that you might be thinking to yourself, I'm not quite sure if this person's eligible to work, shouldn't play any role in whether you hire that person or not. You'll know when they don't provide you with authentic I-9 documents, and that will be when you end the employment if you've gotten that far. Okay, so we said that you have to have at least 4 employees before the anti-discrimination provisions kick in under URCA. And the reason for that is if you have such a small workplace where you only have 3 workers, your level of sophistication about I-9 stuff is not going to be especially robust. And you probably don't have enough money to hire a lot of attorneys to help you become familiar. You're probably a jack of all trades. You're the HR person and the everything else person. And so it's just a recognition, not that you should be discriminating against people, but nobody can know all of the laws, and a truly very small business owner is not expected to be able to dot every I and cross every T. So once you hit the threshold of 4, though, you are expected to comply, at least not to intentionally discriminate. And one of the exceptions is that the person, if you have 2 candidates for the job, one is a U.S. citizen and the other isn't a U.S. citizen, but they have essentially identical, or they're equally qualified. One is not more qualified than the other. That the employer can use citizenship as a tiebreaker. But if the non-citizen is more qualified, then this exception doesn't apply. Now, we've already talked about the public function exception. Let's consider 2 scenarios where these rules go into effect. Adjoa, a Ghanaian, applies for the post of a librarian. She's a permanent U.S. resident who is authorized to work. Mary, a U.S. citizen, also applies for the job. Adjoa is more qualified, but the selecting officer hires Mary simply because he thinks, well, Mary's a U.S. citizen, so she's probably going to stick around longer. Keep in mind, though, that Adjoa is a permanent U.S. resident. But even if she hadn't been a permanent U.S. resident, if she's more qualified than Mary, it would be unlawful for the hirer to hire Mary over Adjoa. And so under this circumstance, Adjoa has a claim under URCA. She's not necessarily going to have a claim under Title VII if it's based upon citizenship, because Title VII does not prohibit citizenship discrimination. Now, Adjoa is, I'm guessing since Ghana is in Africa, is probably of African descent. And so she could change her claim to a race claim or to a national origin claim if she wanted to. But if it truly was just a matter of which one's a citizen and which one's not, then her best course of action would be under URCA and not Title VII. Let's consider Jing's situation. Jing is a Chinese citizen who has eligibility to work in the United States. It's a different Mary here. Mary is a white American woman, and they both apply for the same job. Mary gets a job, Jing does not. And under this scenario, under URCA, Jing would have to prove not just that she's as qualified for the job as Mary, but that Jing is actually more qualified than Mary. So these are the types of remedies that the administrative law judge, the ALJ, can give to a successful plaintiff who alleged discrimination under URCA. So it can require that the employer actually hire the worker, and also award the worker pay that the worker would have earned from the time that the decision not to hire was made until the instatement can happen. There can also be a fine paid. If the ALJ, the administrative law judge, though finds that the employer acted in good faith, meaning there was more of a technical error than a willful error, then there's the potential for there not to be any fine, and the employer may be able to correct the error when they become informed of the error. And these are called paperwork violations. So imagine that the employer filled out the I-9 incorrectly, but it was just a matter of somebody had not been adequately trained where to put particular pieces of information. There was no indication that anybody was hired who wasn't eligible to work. Well, that's what's called a paperwork violation, and many times it can be fixed without any kind of fine. Let's talk about acceptable documentation. So an employer can't tell the employee which types of documents to provide because the employee may not be eligible, may not have certain documents. Again, if you are a native-born U.S. citizen, you're probably going to go the passport route or possibly the Social Security card with the driver's license. Those are going to be readily available to somebody who is a U.S. citizen. But if I'm a citizen of Costa Rica, I'm not going to have a U.S. passport. And I may not have a U.S. driver's license. And I may not have a Social Security card. I may have a green card or something else. And so an employer can't require a subset of I-9 documents. The employer has to be willing to accept any of the documents that are permitted by the government for I-9 purposes. To limit the acceptable documents is called document abuse. So when the employer says, these are the only documents we're going to accept, I'm going to be honest with you. I understand the temptation that employers have because many of the acceptable documents are, there's so many of them. And if you have a clerk who, isn't the most sophisticated, has other parts of his or her job, this is just one part, to put him or her in a position to research whether this particular document is okay or not, can be a rather overwhelming part of the process. Plus, some of the documentation is just a stamp in a passport. And so when one looks at it, one's like, well, gosh, wouldn't that be super easy to forge? Is that legit? Does that really do what it needs to do? And so there can be some questions along those lines. So I understand the temptation that an employer has. Well, let's just stick with the tried and true. Let's just stick with the usual stuff we see all the time. We know what that looks like. It's an easier number to manage. I understand that temptation, but it is completely unlawful to do that. Document abuse is not acceptable. Now, if an employee says, well, what am I supposed to bring for this I-9 purpose? You can refer the employee to the website that would provide that information, the government website to provide that information. And you can certainly say, well, most commonly employees bring a U.S. passport that's unexpired, or they bring their Social Security card and their driver's license, or their U.S. birth certificate and driver's license. But those aren't the only documents. That's fine to give them some ideas about the documents to provide, as long as you don't say, and those are the only ones we're not going to. Those are the only ones we are willing to accept. Let's talk about Section 1981. Again, we've talked about this in the context of race discrimination. We talked about how some courts have extended it to national origin. Much of this is due to the fact that when Section 1981 was passed, it's a Reconstruction era law that has been amended since then. But at that time, race had a more expansive meaning in vocabulary. Words evolve over time. And so race really meant both what we think today of race as race and also national origin. Some courts apply that meaning to the term racial discrimination used in Section 1981. Some courts have declined to do so. So it's one path. It never hurts to try that theory, but it's not a guaranteed win. Under the Civil Rights Act of 1866, which is where Section 1981 began, all persons within the United States have the same rights to make and enforce contracts, to sue, to give evidence, and to equal benefit of all laws as they are enjoyed by Caucasian citizens. And so you can see here, this isn't restricted just to citizens, but to all persons. Again, this has been construed because it's not restricted to just citizens, so it includes aliens as well. The Civil Rights Act of 1991, you don't need to know this year, but it extended the protections not just to government discrimination, which used to be the law under Section 1981, but also to private discrimination. So this change significantly increased the scope of Section 1981 for potential plaintiffs. So here's some management tips. Employees can file national origin discrimination and harassment claims even if they've just been perceived to be of a particular national origin. After 9/11, there were several incidences where people who weren't Middle Eastern or who weren't Arab or who weren't Muslim were beaten up and harmed because the criminals were not only criminal, but they were stupid. They didn't know that they were dealing with somebody who wasn't even of the ethnicity that they thought that they were. So the discriminator doesn't have to be right. They can still be guilty of discrimination if they had incorrect assumptions. Customer preference, client preference, coworker preference, none of that can be a requirement for a job under national origin. But if you do decide that something is a requirement, such as you need to be a citizen of a certain country in order to be hired into a certain position, just be sure that you make sure 100% of the people in that particular job satisfy that. If you have a single exception, the BFOQ, the bona fide occupational qualification, goes poof, and you won't be able to assert that for any of your incumbents. If you're a federal contractor, and that's a big decision to make, if you decide to go, it's one of those things, if you're in for a penny, you're in for a pound. So you want to make sure you don't cross that threshold. It's $50,000, at least it has been in the past for many things. There's two levels, but one of the levels I think is $50,000. And if you cross that threshold, you're going to have to assume a lot of responsibility. So make sure. What you don't want to do is cross that threshold and only get a contract for $50,000. You want to make sure it's worth your time as a business. And then as you are developing policies, be sure that you're complying with both Title VII and IRCA. And continue to be aware of the fact that Middle Eastern individuals, Arabs, and Muslim individuals can still experience discrimination in our culture. We've seen that also with COVID-19, that Asian Americans and Asian aliens can experience discrimination simply because someone might perceive that perhaps they might be Chinese. And somehow or another, then COVID-19 is their fault if they happen to be Chinese. It doesn't make sense, but people who do things like that aren't necessarily the most sensible people. Anyway, so those are some things to keep in mind as you assist clients in navigating through these issues. As always, if you have questions, feel free to pop into my office hours. I'd be delighted to talk with you in more detail about these topics. Thank you so much for your attention, and I hope you have a wonderful day. Take care.